Good afternoon, ladies and gentlemen. Welcome to the Australian League of Rights webinar. We've got a pretty wide audience, most likely, so some of you might not know about the League of Rights. It's been around for a bit over 70 years. It is a conservative political body. It is not a party. It doesn't seek any power for itself, but as a bit of a guide to what it does stand for, the support for a monarchy, the flag, limited constitutional government, the bicameral system of parliament with the upper and lower houses, decentralisation of economic and political power wherever possible, namely the federal and state and down to local government. That creates a division of power, and it encourages personal responsibility for citizens to play their part in our society, particularly at the political level. Normally we have these seminars in person, but due to the COVID environment, this is our very first time conducting the webinar. So the advantages, of course, are that you can stay at home at leisure, you can have your old socks on if you wish and all that sort of thing, but the disadvantages are that we don't have the pleasure of shaking hands and socialising with our guests after the event. So today the subject's going to be about freedom and rights. You know, we have Australia Day and we have Anzac Day, and everybody is very strong in their mentioning about how Australia's a lovely country and we've got all these rights that the soldiers fought for and our political system is so good. Those 2 days are shadowed by 363 other days when I'm sorry to say, but most people don't take any interest in maintaining our rights and our freedoms. And if we aren't aware of how we're losing them, you just have to think about those poor people in Victoria and in Melbourne in particular. They have been under severe controls, and I'm not saying that we shouldn't have any controls in those health issues, but I would quickly follow that up by saying it's completely over the top what they've been doing. There's plenty of other rights and freedoms slipping away from us, but that is the one that is a focal point at the moment. Today we have 3 speakers. There's going to be a gap after the first speaker for a comfort stop, and between the second and third speaker we'll have an extended break so you can enjoy a cup of tea or whatever you might like. The speakers will speak for 45 minutes and that'll be followed by 15 minutes of Q&A. There'll be thanks at the conclusion, and for your information, the whole show will be recorded. So if there's any reason that you have to leave the scene, don't worry, you'll be able to catch up later on. So I'd like now to welcome our very first speaker, and Robert Balzola is a lawyer from New South Wales, and he's going to be addressing the legal aspects of our loss of freedoms and rights. Robert was admitted to the legal practice in New South Wales in 1995. He holds degrees in law and economics and theology. I might just say right now that the 3 speakers we have today, they're all very dedicated Christians and have a strong faith. So I think in some of their cases, that's what's got them through the difficult times they've been through. So Robert practices in the areas of administrative law and constitutional law. Well, that's going to be an important one for today. Robert has successfully represented people who have been victimised for standing up to their rights, and he has an appreciation for the League of Rights, and he's shared our platforms on previous occasions. So I should mention too about questions. Being a webinar, you'll have to try and use the chat section if you wish to raise a question. It's a little bit more difficult today. But I'd like to welcome to the podium now our first speaker, Robert Balzola. Thank you, Robert.
Thank you. Can you all hear me clearly?
Yes.
Okay. Thank you, Ken Grundy, and credit to Arnie Lukes for putting this technical support. He's always had a very strong technical capacity, and today's par excellence, he's been able to continue the tradition, to my knowledge, unbroken tradition of this conference, which is held annually in Adelaide. As was said earlier, we typically meet physically in a meeting room at the great Sanford House of great antiquity in Adelaide. Unfortunately, because of restrictions, we are unable to do that. And to my knowledge, correct me if I'm wrong, through you, Chair, Mr. Grundy, that this is the first time we've held a conference by electronic means. Is that correct? Probably yes. So anyway, I have also put a PowerPoint presentation, which I have shared the screen. Can everyone see the screen? It's titled "One Voice Against Evil, One Voice for Freedom." Is that being broadcast at this moment? Just
yes.
Nod your head or give me a yes or no, because I'm going to be addressing that presentation today. Now, the speaking time I have is from 13:15 or 1:15, 1:15 to 2 p.m. Adelaide time. I understand there's at least 60 or 70 people online at the moment, probably more as we go on. And whatever time you're watching this, 2 a.m. in the morning or 6 a.m., wherever you are around the world, welcome to Adelaide. I'm presenting from Sydney. The opening topic, which was given to me by the brochure that was distributed, is actually a quote from the Honourable C.H. Douglas, and the quote is from a text which he wrote, first published in 1936, titled "The Tragedy of Human Effort." And I want to touch on tragedy. The quote is, "Security in what we have is required, freedom of action, thought and speech, and a more abundant life for all is wanted." And in true style, it would be essential that I address that topic, because that's what the topic is. So I will focus my comments addressing that quote from the main text called "The Tragedy of Human Effort." Now, Mr. Grundy did say that my area is in law. Bernard and I are something of a pair, but Bernard's one of my long-standing clients. I will not discuss specific items out of client privilege to him, but what I will do is speak from a strategic legal perspective, very much the focus of what Douglas wrote in Tragedy of Human Effort. And I think it's very interesting that Arnie Lukes selected that text of all the works of Douglas, because it's highly poignant to the opening remarks of Ken Grundy about the 365-day quote, about we have one day a year where we celebrate the freedoms and liberties of Australia, and we spend the year, that's 364 days, seemingly ripping those freedoms apart. Credit to my succeeding speaker, which will be Bernard Gaynor, who has been extraordinarily forthright and steadfast against a lot of encroachments, which I will touch upon, but I don't want to make this a legal lecture. This will be very much a high policy presentation, and specifically, and I'll be quite pointed on this as well, in direct answer to C.H. Douglas's text, "The Tragedy." So let's move on. Let's see if this is working. Why aren't you working? Oh, here we go. Now, the topic, the header is titled "Good and Evil," and good and evil presumes divine law. Now, people who are unfamiliar with the four protocols of law, what we call law is actually called positive law in philosophy. And positive law sounds positive, but it doesn't mean that at all. It just means positum, which is Latin for laying down. Much of what Bernard Gaynor and my other clients, and basically a lot of other people, have been suffering is laid down law, known as statutory law, common law, judge-made law, tribunal-made law. As natural people speak of law, is actually the lowest protocol of the laws. There are four protocols of law. If you read your Summa Theologica of Aquinas, who perfected this model, there's the natural law, which Arnie Lukes speaks heavily of, and so does, of course, King Grundy and the TOR, the Australian League of Rights. But then there's a moral law above it, and then there's a divine law. And that's not a point missed by Douglas either, who refers heavily to these higher laws. And the old saying, a law that does not conform to the natural or divine law is not a law at all. That was the conclusion of Aquinas 600 years ago. And that presumption that a human law that does not comply with the natural, divine, and moral law is no law is as completely valid today as it was when ancients such as Aristotle came to that conclusion himself. There's nothing new in these, everything that I'm going to be saying today. So the heading of today's talk about good and evil presumes divine law is an essential point to remember. The eternal law, for those who don't remember, is do good and shun evil. Now, for those who might be saying that I'm deifying this talk today, is probably right, I am, but I'm not going to shy away from the higher order of laws and the compliance and conformity with them. This is not just theory. I want everyone to understand that the Australian League of Rights and its main themes of emphasising the good works of Douglas and social credit is not only just not theory, it's actually been applied right up into relative history. The Commonwealth structure that we enjoy in this country, and of course my good colleague Oliver Hayden from Canada will know well that who is a Canadian citizen, will know well that the foundations of Australia's jurisprudence is based on natural, divine, and moral laws. There's no accident in that, and it is indeed a testimony to the constitutional integrity, the federal integrity, and the success, the enormous success that was Australia. And that social credit theory, when I did some research just a matter of a week ago, looking up the New South Wales Parliamentary Hansard, for those international people, you know we've got 6 states of Australia, that social credit was a very major, well, it was the central philosophical economic theory driving Australia's success. The National Roads Program, the wheat industry, the coal industry, the Snowy Mountain Scheme, the Commonwealth Bank when it was with its system of 2 payments a year. All of this was based upon social credit. Members of the upper house of the New South Wales Parliament, like the Honourable Con Cannon MLC, was speaking about this. I was surprised to see how many times social credit was being actively debated inside our parliaments up into the late 60s. So it's no accident. This is very much a hijacking that we're now in this consumerist speculative economics that is in opposition to natural economics. And that's a point that will be made earlier today. So there's the divine law, which I've touched on, and I've touched on the 4 laws and the hierarchy of laws. And again, the laws that are being made, the laws that certainly Bernard and other response to the very many attacks on his liberties. He's a celebrated publisher by electronic means. He has a very famous blog, which has many tens of thousands of viewers. He has a strong following, and his main, but I'll let him describe himself, but I understand his main vocation in life now is to publish texts and research. And he's been relentlessly attacked precisely because he publishes contentious but true points in policy, which draw the wrath and venom of our common enemies, those that want to destroy freedom, those that want to destroy speech, etc. And for that, he has been relentlessly attacked, and I'm sure he will take you to that today in his speech without taking his thunder. So I just want to touch on the word tragedy. My master's degree and what I practice heavily in is planning and development law. And when I saw the text that was being referred to today, I could not help but draw the analogy. The actual text from Douglas is titled "The Tragedy of Human Effort." The very quote is from page 5 of Douglas's text published by the Institute of Economics in 1936. Now, the one cornerstone article that we were taught, it's Environmental Law 101, is The Tragedy of the Commons. I wonder how many of you have heard of that document, The Tragedy of the Commons. And the tragedy, like a Greek tragedy or a drama, for those of you who go to theatre, those of you who like, how's my sound, by the way? Are you all hearing me loud and clear? Just nod your head yes or no. Is it all okay? Thank you. That the tragedy of the commons is why economics gets the nickname the dismal science. because this is a quote by the first known use of the word tragedy of the commons was by William Foster Lloyd, who lived in the late 19th century, born in 1794, died in 1852. And I'll read it because it's this word tragedy is stuck in the psyche of modern economics and made it such a dismal science. And I'm going to juxtapose that against what it means to be a Christian scientist, particularly with respect to how we have a not only a Christocentric perspective in opposition to an anthropocentric perspective, but how we see economics, how we see social justice, how we see politics, and how we see law. And this is not just some idle philosophical banter here today. One thing you will get clear, and the reason why ALOR, the Australian League of Rights, have put me up and Bernard up is because Bernard is eminently a practical man and has been extremely successful against pushing back what was runaway, what I describe as proto-dictatorship. We are just a hairbreadth away from the unfolding events in the United States: full-scale anarchy, devolution of government, destruction of police forces, burning, looting, rioting. We are maybe not in that same category yet, but certainly the US, well, we used to say the US sneezes and the rest of the world catches cold. Well, now China sneezes, we all catch COVID. Well, that's a different story. But the fact is, this quote, Tragedy of the Commons, by Professor Whitehead, and I'll give the citation at 7 if you want it. The essence of dramatic tragedy is not unhappiness. It resides in the solemnity of the remorseless workings of things, and this inevitableness of destiny can only be illustrated in terms of human life by incidents which in fact involve unhappiness, for it is only by them that the futility of escape can be made evident in the drama. The author of that first quote was Foster, but that's quoted by G. Harden in the Science Journal of 1968. I bring that up because it isn't a tragedy, and the alternate model of certainly natural economics, natural philosophy, natural justice and natural law is one of profound optimism. And that's not because we have some weaponry. I mean, I'm going to put a philosophical question to Bernard here, who might want to answer this. Why do you think we're winning at all? Is it because Bernard's a nice guy and the judges like him? Is it the judges like me? Is it that we're just smart-ass lawyers, pardon the language? It's none of those things. We win because, and I'm quoting Justice Brennan in his opening speech at the University of Notre Dame at Sydney, which I was on the board for several years. He said, "We will win debates as we always have, by weight of argument and force of numbers." That was Justice Brennan. He said, "We'll determine these disputes the age-old way. Get out onto the moors and the morrows with a sword in our hand, and we'll smash the other guy down until there's one man left standing, and that'll be it." So, and we do that symbolically in courtrooms these days with wigs and gowns, force of argument and weight of numbers. Who are the weight of numbers? The judges. It's from 1 judge to 7 judges. Bernard's won 5, well, 3 and 2 when we include Tess Corbett, 5 High Court decisions. Why? Because 7 High Court justices said yes. Full stop. That's your numbers, okay? Weight of argument, we had mixed victory there. Not all our arguments got up. The Commonwealth's arguments didn't get up, but ultimately, like a battlefield, you win a flank, you lose a flank, but ultimately you win the battle, okay? It doesn't mean you won every melee. It doesn't mean you won every argument, but you won the day, okay? You still came out of it with casualties. Who said we didn't get hurt? We all got hurt, but at least we won. So I want to touch on this issue about tragedy, and that is a dismal look at the wording: unhappiness and remorselessness, and life is just one endless treadmill of entropy. That's not a Christian perspective, at least. It's certainly not a natural economics one. And to answer my own question, Bernard has been winning anything at all is because he has the weight of argument. He has the force of numbers on his side, and that's going to continue, even as late as last week. New South Wales Parliament. Okay, the amendments to the complaints handling legislation of the Anti-Discrimination Act, which has consumed so much of Bernard's time, hasn't been a complete victory, but I commended him only yesterday, saying it's a very good start and it's more than anyone else has done, and at least, at a minimum, he's pushed them way off their mark. I mean, if this was a wrestling match, that the other side's at least on the line and possibly going to be pushed over and pummeled. So I just want to make this point because it gets raised a lot of times about the Magna Carta. There's nothing new about the Magna Carta, and there's nothing new about 2020 where we're living at the moment. For those who don't remember their Roman law, the 12 Tables was a conflict of the plebeians and plebiscites and the patricians, I should say. It was a class struggle where the lower classes, the plebs, basically got sick of being treated like garbage, and they literally went on strike. They left, they vacated Rome. They said, we're not going to cook your food, we're not going to clean the streets, we're not going to pick up the garbage, and they left. The Senate made these 12 tablets. And you heard the word chiseled in stone, but this was actually cast in bronze. The Romans were very practical people. And that's why the tablets physically exist today, because bronze doesn't rust. Stone can break, but it's much harder to break bronze. And the Senate wanted to make a point. We're not going to chisel it in stone. That's an old saying. That's not actually the strongest way to do it. You want to make something that lasts, chisel it in bronze. Okay, so that was the point. The Magna Carta is just, of King John of 1215, is just a rehash in some sense of forcing the king to the table and making a set of rules. But that whole exercise had been done at least 700 years earlier. Oh, sorry, take that back, 1700 years earlier. And I want us to know that the more things change, the more they stay the same. History does repeat itself. And I also have made the point forever, and I hope this is being recorded, I know I'm recording it, that statutory enactments are false security. I don't know how many times I've mentioned this with marriage law, with abortion law, with euthanasia law, with you. Words on paper can be erased. Is that clear? It's never good enough to say, oh, it's chiseled in stone. Marriage means one man and one woman to the exclusion of all others for life. Do you know where that comes from? It doesn't come from the Family Law Act, although it got statutory recognition. It doesn't even come from our common law tradition, although in the Crown against the Queen against the L in 1991, again, Justice Brennan expressly, 5 judges in the High Court in 1991 declare that marriage is ordained by the law of nature. It's in our High Court decisions, ladies and gentlemen. It's not just some statutory provision. And where did Justice Brennan, who was doing the talking in Queen and L, come from? He went right back to Lord Penzance in Hyde against Hyde and Woodmansey. He went right back to the Privy Council. He went right back, and indeed Lord Penzance went right back to ancient Roman law and said, what is marriage? What is the institution of marriage? And what is a husband? What is a wife? And it took His Honour, Lord Penzance, 3 days to explain that. It was a huge debate. But the fact of the matter is, there's nothing new in what we're experiencing here. And I regret to say, why are we going like a washing machine around and around? And why is Bernard suffering and others worse than Bernard's case? Well, these are in the top 3 of the most affected people. The codification is only good if there is a cultural change. And that is what the earliest introducers, Mr. Grundy and Arnie Lukes, who is very, very well read, makes about the point about culture and also the fact that there has to be cultural change as well as codification change. We can repeal these laws. We can repeal the Marriage Definition and Religious Freedom Act of 2017 of the Commonwealth, which we're going to do. We can repeal the Racial and Religious Tolerance Act of Victoria. We can repeal the Discrimination Act of 1991 ACT. We can repeal the Anti-Discrimination Act of New South Wales 1977. We can repeal them all, and we'll still be left with a bunch of people who want to do it all again. So writing laws and unwriting laws is a mechanical, or what Douglas refers to as a practical, when I read his Tragedy of Human Effort, and, making strong analogies to military force, that's the mechanics of what Bernard and I do, but underneath that is cultural change, and I'll touch on that in a moment. The other topic that is raised is in the theme of today's quote is about security. So I need to touch on security, and of course the main theme of Douglas, which is security, is about economic power. That's one of the main themes of Douglas's works, which includes monetary and fiscal policy, and the great cornerstone of social credit being monetary policy. How were things paid for. Exactly, this is anathema. This is apostasy to the modern world order. Print money. Okay, monetary policy means pay cash. The last thing you heard about cashless society, well, this is exactly the opposite to cashless society. And I ask you a question to think about. If every person holding Australian dollars went to the bank tomorrow morning and asked every super fund, every offshore holding, every foreign government, every Chinese dollar, went to the bank and said, I want my Australian dollars in cash, could the Australian Reserve Bank honour that demand? Not a hope. Money, as we understand it, are numbers on a computer screen. Physical cash is a decreasing percentage. In other words, in monetary policy, you could print $5 billion, $10 billion, $100 billion today, and its economic impact in terms of inflationary velocity of money policy would be almost negligible because there are so many nominal dollars out there holed up in computer screens, but they don't have any physical corporeal reality if you translated them. So I want you to just take a look at these 12 tables and just see what was happening 500 BC. Look at table 1. It's all about property rights, procedure, courts and trials. Further enactments, table 2, execution of the judge. That's the judicial stuff. But then table 4, rights of familial heads. That's an economic right. 5, legal guardianship inheritance laws. That's an economic right. 6, acquisition and possession. That's an economic right. Group of rights. Table 7, land rights and crimes. Self-explanatory. 8, torts and delicts. Self-explanatory. 9, public law. 10, significantly, back to my divine law, sacred law. So if you think there's anything new about this, that was written 500 BC. And Alphonse's Carr famous quote, the more things change, the more they remain the same. Nothing's changed, ladies and gentlemen, nothing at all. So Douglas is a great advocate in this field about social policy and justice. By the way, the National Civic Council just recently published another text on distributivism just 2 days ago. I think a lot of people, don't for 1 minute, I pride myself on one thing. When I give presentations, very little of what I say is from me. I rely on better persons than myself for one reason. Most of what's been out there has already been said. Someone has said this and come to these scientific conclusions well before Robert existed. So this is really a summation of a map to ground, where are we now type thing. The good end of law is justice. What do you think the good end of politics is? Justice. This is just some Aristotle 101 here. What's the good end of economics? You got it. Justice. Justice, justice, justice. All right. There are different types of justice. There's legal justice. There's political justice. There's economic justice. They are different subsets of justice. But if Aristotle was sitting in this conference right now, he'd be saying you're dead right. The answer to all 3 questions is justice. Now, what does affect me, and this gets back to the word the tragedy, is that the Enlightenment philosophers, so-called, which is a great oxymoron, have destroyed science from the equation. We deal with the German philosopher Wolff, then the French revolutionaries, Robespierre, Comte, Voltaire, Rousseau. Then we get to the English philosophers, Locke, Hobbes, Smith, Bentham, Hume. It's philosophy devoid of science. Now, what is science? The first thing they had to do was destroy philosophy and theology from the main economic debate. So when we talk about natural law, natural justice, natural economics, what's natura? Natura is the Latin word for reason. That's all it means. The Greek equivalent is prudentia, from the word prudential. Okay, so if we hear the word prudential, the insurance company, it means reason in Greek, and so natura means natural, means reason in Latin. It's been taken out. Now, in contradiction, and I'm going to rebut, be devil's advocate here against the tragedy text by Douglas. What about, if everything is so fatalistic and so destructive, where does Trump come from? Where does Donald Trump come from? Now, those triumphal arches that you see that are army, military in Anzac reserves and parks. It's a famous quote, thanks be to God who gave us the victory. You remember that famous quote? That's a very common, if you see those triumphant arches and then their rolls of glorious dead, you will also see that quote used a lot. Does anyone here seriously believe, and I'm quoting Douglas in his text on this, does anyone seriously believe? I'll quote what he says. Quote, moral, this is at page 5 of the tragedy text that he writes. Moral, intellectual, and emotional considerations unquestionably go to the determination and use of direction of physical force. But in the last resort, the last squadron of bombing aeroplanes will have its way when all the navies, armies, and aerial fleets of the world are destroyed. And in the last event, the problem of sanctions is to obtain control of that last squadron. That's what he writes. Now, I do not have such a view of war. Otherwise, I wouldn't be leading or advising clients into court cases where it was only going to come down to who's got the bigger bombers or the last bomber squadron. There is a higher force at play here. And we're witness to that today in this conference right now. I know Trump's got more skeletons in a closet. I mean, they're not even in the closet. They're out for all to see with Deutsche Bank and other scandals. But the bottom line is, God uses people, uses events, and uses battles for a higher cause. And whatever's going on here, you know what the biggest enemy of Trump is? It's the Pentagon, because he's pulling troops out. He's reducing military strengths around the world because it's just a waste of money. Why have we got a US army in Germany? Total waste of money. They were there to stop the Soviets going into Hamburg. Well, that ceased 70 years ago. That threat, there isn't even a Soviet Union anymore. So I just make the point that taking the metaphysical and the ontological and the providential, most importantly, I'll touch on providence in a moment, is a direct rebuttal to this tragedy of this entropy and this gloomy science that we're all doomed and we're just random atoms in a chaotic cosmos. So the perfection, as we say, of God's justice is found in principally public revelation. It's found also in empirical fact. Anyone who thinks that I'm just being dewy-eyed and deific about this is completely incorrect. We are not just witnessing. Nothing is by accident. And let us be clear about this. I mean, what was said about COVID-19, said, describing it as a plandemic with an L. Yes, that's probably true that someone out there has been conspiring and devising and planning this for decades, and we have our suspects. But at the end of the day, so does God, so does other people. And there have been other plans going on in parallel and playing a sophisticated game of anticipatory chess. And that is the real world. I have sublime confidence in the ultimate justice of things. I mean, what escapes the minds is that, again, citing Douglas, where he says from that tragedy text again, the theory of the later Roman Empire maintained led to Rome's downfall, not by conquest of stronger armies, by its own internal dissensions. Well, that quote doesn't acknowledge the fact that the 12 tablets were the beginning of an empire that lasted over 1,500 years and is arguably the greatest empire ever created. The tablets were the beginning of the great empire of Rome, which has led to the contributions to our lives that we know today. The three arms of government, things you take for granted, those very freedoms you speak about, where do you think they came from? Well, England didn't just invent them. Their common law was garbage until the Romans came along. Then they evolved into the great jurisprudential tradition that we've absorbed at Federation. So you do your best and God do the rest. That's what inspires me. I'm being clear about it. This is a spiritual warfare. If you engage with right reason and force, providence will follow. I have never ceased to be amazed how many times I thought we were sunk in the river and how many times we got pulled out at the last minute. That it will come to good. If one, I don't need to give you quotes on that. But faith without good works is dead, and that's the bottom line there. So I'm going to put that up just to remind us of James 2:26. The actual, how are we going for time, Speaker? Are we okay? About 15, 20 minutes? Thank you. Deal with the freedoms. Freedom of speech. This is one of the main fortes of Bernard Gaynor, and of course a great number of others. I'm only focusing on Bernard because he succeeds me as the next speaker, so I thought it's natural that I should link my address as some sort of a long introduction to the main speaker, who I think in my view will be the other two speakers, Watson and Gaynor. And of course, freedom of conscience. Now, these are freedoms, but as I'm about to show, law is about balance, reprobate and balance. It's not just about freedoms. This is another revolutionary, French revolutionary, Freemasonic seduction. Your rights, your freedoms. They never tell you about your duties, your obligations, the composite and corollary. For every force, there is an equal and opposite force. My freedom of speech is my duty to listen. Okay? My freedom, and that's what is indeed the hypocrisy of the current psychology, that we're told we're not allowed to have freedoms. Indeed, deontology is one of the main philosophical cornerstones of what is deontology. It's the philosophy of duty obligation. That's one of the philosophical cornerstones of totalitarianism. Okay, deontology is the philosophy of duty obligation. You will obey orders. You will subordinate yourself to the state. That's common to Nazism, fascism, socialism, statism per se, socialism. They're all the same, including capitalism, ironically. Capitalism is no friend. If the NCC were listening to this, because they just published texts on this, they're absolutely right. I love the texts that they produce. They're a great think tank, at least equal to the ALOR in terms of the quality and learnedness of publication, in terms of their philosophical certitude. And that's why they should be read with great care, including, of course, Douglas. One has to read everything with great care. But those who have put serious thought into this realize, and of course, liberalism is more commonly known, which is whatever's in my head is right. There's no other. You're not right. In your heads, your opinions, your thoughts. You're not right. I'm right, because what's in my forefront of my lobe here is the only truth there is. Those two great errors, liberalism and deontology, drive our secular ideologies of humanism. Humanism, of course, is just human perfection, but perfection to what end? And this is where, again, Douglas, I know I'm quoting the tragedy text a lot because I'm compelled to address the tragedy text. His bottom line is basically, I don't want to misquote it, we must take the human condition by force to its logical conclusion. And that the individual ends, I'm paraphrasing, I'll get the quote, only lead to totalitarianism, says Douglas. If individuals are left to their own devices, and I have to give Douglas credit. He can't be talking about personalism. He must be talking about individualism. And if he's being authentic to that terminology, and I've been told, and I agree, Douglas is like Aristotle. You've got to know what he's writing. He presumes you know what he's talking about, and if you got to use his words at full value. So he says individual ends lead to totalitarianism. So his idea of the state, I could quote the actual section, is got to take the state to a point where it becomes a system of trial and error, and that by what we say by force. Yes, I'm quoting, the individual aim is ultimately a totalitarian aim, Douglas writes. But if that's true, then his means to an end, as what he calls the purely materialistic, is we have to enforce a government which will not lead to a totalitarian end. Which, yes, if the necessity for coercive force is necessary to stop a totalitarian regime, then we will need laws made that prevent that. In a common law sense, that's exactly what Bernard Gaynor's doing at the moment. We're having to amend laws, and there's some degree of success, a long way to go. But I just wanted to make the point about this terminology, like tragedies and like freedoms, all come from the French Revolution in modern history, although these points were debated in ancient Greek history and Roman history, and even before that, the Rosetta Stone. We can go back to Babylon, we can go way back. There's nothing about this debate, that the Declarations of the Rights of Man and Citizen of 1789, which was exactly at the same time that you had people like William Foster Lloyd, 1794 to 1852, getting swept up, and of course Adam Smith in his Wealth of Nations of 1776. They were all being shifted off the mark, taking their eye off God. And Adam Smith, for example, speaks about the invisible hand. The Freemasons and French revolutionaries speak about the divine being. All of these are analogies to God, but they're not God. And the fact of the matter is, from that, we get to this devolution of things like tragedies and the dismal science, which is a far cry from what natural economics, natural theory, distributivism, and ultimately social credit is really all about. That tablet over there, you see it bears striking resemblance to the Ten Commandments, because I were trying to replace, such as Baron de Montesquieu's three arms of government of the three levels of Godhead, Christ the King, Christ the Prophet, and Christ the Judge, just gets supplanted with executive, legislative, and judicature. There's no mention of duties in this Bill of Rights, the Declaration of Rights. It's all solar rights, my right, my right, my right. You never hear a thing about duties. This is relevant to Bernard, of course, and relevant to all of you. Don't for 1 minute think that this is just about Bernard or me or John Sunol or other great sufferers who have gone through enormous travesties. The fact of and I mentioned John Sunol, for those who don't know, he trumps, if I can use the word, Bernard, not that I want to diminish Bernard's terrible ordeals, but Sunol's had far more, and I will give him recognition for the fact that he's been probably the most singularly persecuted person under so-called anti-discrimination laws so far. But this solar rights, what we're actually doing, if I can be technical and legal for a moment, enforcing statutory and common law powers against administrators. Now, what's administration got to do with anything? Again, back to the tragedy of the human effort by Douglas. Administration is a key theme in Douglas's text on tragedy. Administration is the mechanical instrument, according to Douglas, of which I agree, if now I am expressing an opinion, of which bureaucrats and what we call deep state control you. Is that clear? It's how the bureaucracy, through a myriad of laws and morass of confusing, befuddling and mesmerizing laws and administrative processes and forms and procedures and appeals, drive you crazy, and you give up and you just can't cope because they are a permanent garrison. The government departments, the Anti-Discrimination Board, the Attorney General's Department, they're your taxpayer-funded money. And I take you to the extreme lengths. For those who are following US politics, the FBI, the CIA, the US Department of Justice, from top to toe, profoundly corrupt conduct, treasonous conduct, scandalous conduct, full-scale treason now to usurp through impeachment and other processes, doctoring of evidence. For those of you who are keeping abreast of the unfolding events, now you might say, well, that's the US, that's not Australia. Oh, really? You think so? We have a different view, and with well-founded reason. We are being played for pups in this country, and I now show absolutely no mercy to bureaucrats. If they make one mistake, when I contemplate what my clients and what I have been through over 25 years of practice, God help anyone in my presence who makes mistakes. Because if the standard being exhibited to us is that high, then so shall we apply the same standard. Thank you. And we shall apply the same standard that they apply. And they don't like it. Let me tell you, they don't like it when they are being bankrupted. They don't like it when they are being struck off. They don't like it when they get malicious prosecution findings in the District Court of New South Wales. They don't like it when police get statutory fines of $48,800, or their government departments have to show cause or amend legislation, which has happened several times. They don't like it when the Department of Defence has to admit administrative error and has to pay tribunal costs and court costs. They really don't like it. And I'm afraid to say that is the nature of the war we're in. Any clemency has now gone out the door. They are acting like barbarians. They think that they can apply laws but not be accountable by them. Well, they've just got a lesson on that. I just want to finish this point on revolutionary deceit. It is seductive because the layperson out there will be as an entire glorious nature called the daughter of the church. France was seduced by this garbage called Declaration of the Rights of Man and Citizen. Yes, the people were suffering. I'm not doubting that they were starving. I'm not doubting it was a terrible time in French history. But this list of, you've just got right, 17 rights is equally false, and is the modern expression of liberalism, which is my rights. And that's why you end up with 14-year-old and children being shot point blank in the face with 9mm pistols in the US, businesses being destroyed by looting and rioting, police officers being killed and being denied to get into hospitals for medical treatment in uniform. The disgrace of this is because of liberalism, because of ideologies that began, at least in modern history, during the French Revolution. Back to Douglas, trial and error is what he describes as the method. It's the tragedy of human effort. Basically, is a thesis on experimentalism, because he says we apply. I could read the quote to you, and that, with respect, is partially true. We have to also learn from our prior knowledge. Philosophy, like any other science, is a cumulative science. You don't start afresh. You have to learn by what has worked before. We have at least 5,000 years of learned history. The great legacy of Australia is that it is indeed a common law country. And a common law country means we have, if I asked you this question for those listening, do you have human rights right now? If you listen to the United Nations and if you listen to our government, you keep getting told this: Australia has no Bill of Rights. Australia has no Charter of Rights. That's what you keep getting told. That's false. Your Charter and Bill of Rights is whenever you walk into a barrister's chambers or a decent library and you see row after row of common law. I see Bernard sitting behind a whole bookshelf of books behind him. He's got about 6,000 books there. So for those who can see his backdrop, and that's not even close to what a legal library looks like. A legal library has rows and rows and rows of common law going right back to the first King Bench and the first Privy Council and the first Queen's Bench decisions of antiquity. We still quote laws going back to antiquity. I appeared before the New South Wales Parliamentary Inquiry recently. He said the chair of that inquiry into the complaints handling bill said, "I remind this committee that we are bound by the Parliament rules of parliamentary privilege." And I said, prior to the enactment of the Parliamentary Privileges Act, Chair, here's your trick question. Were there parliamentary privileges before that enactment? Back to my positive law argument. The answer is, of course there was. Your rights are enshrined in common law. Your freedom of speech, your implied constitutional freedom of political opinion, your right to silence in a criminal trial, your right to not make a commitment of an act of self-incrimination. There's so many rights you have. Where do you think those laws come from? A statute? There might be some codification, but by and large, your rights are embedded in 2,000 years of English common law jurisprudential history. And I do say that the success that we enjoy does come from at least 500 BC, but I say that wasn't the beginning. As I say, Rosetta Stones, there are other milestone epochs in history where great stability. Aristotle's book on politics was all about looking at those Greek states that were successful and those Greek states that were failures. And he noticed which of the city-states prospered and thrived and which of the city-states were catastrophes. And he found out it was all down to the governance. It was all down to rule of law. And I also say that the Magna Carta and these epoch moments are so powerful that we are not just a dismal science. I'm not saying this to attack Douglas, but I couldn't help but read the author's point in this tragedy, that it would have us think that we were just subjected to entropy and the dismal science of these individuals running around and acting in their own self-interest. Very much a Platonic argument, Plato's Republic. We're all just consumed with self-interest, and that the only consequence of that can be, as Douglas says, totalitarian regimes popping up all the time. If that's the inevitable conclusion of our society, then we're all doomed, aren't we? I don't think so. I say that our Christian heritage says that if we are faithful, if we do apply the natural, moral, and divine laws, and if we are steadfast and forthright, we will prevail over this evil. That's the code of chivalry, that we attack and defeat evil. As a fellow knight, we attack and defeat evil so that it shall not prevail to harm others. And that's exactly the point. And Trump's main enemies are Pentagon and the military establishment. For those of you who don't know, it's not the Democrats, not Biden, it's the military establishment. They hate his guts. He is taking their money away from them, and they hate it with more hatred than one can imagine. I just want to touch on these. I know I'm getting a bit behind in time, I think, so I better speed up. In church and philosophy, Descartes, one of the main French philosophers of all time, on the doctrine of divine providence, we live in a world of an intelligible God possessed of free will. That's what we believe. Okay, so Adam Smith talks about this thing about invisible hands. That's hands without a body of God. The modern talks about no hands or fate. It's just fate, entropy, chaos, and inevitability. Thank you. Elimination of God from the equation, philosophy and metaphysics, and law becomes a categorical imperative, such as Immanuel Kant and John Finnis on natural law devoid of God. I just want to make the point, this is the church teachings on rights and duties of personalism and individualism. It's well documented, ladies and gentlemen, as to what is personalism and the rights, duty, obligations. I just want to touch on the main headings of the main themes of Douglas, which are license of finance, power, and the centrality of economics. And I definitely agree on this notion of the national dividend, which is a cornerstone and subordinate science of distributivism. What is to be done, finishing on the positive note, application of the natural, moral, and divine laws. I'm not making this stuff up. I can quote Justice Brennan all day, Queen Anell, Hayden, Woodmansee, Khan against Khan, Court of Appeals, Victorian Court of Appeal. There are other judgments. Enforcement of economic, legal, and political justice through the conformity of our natural laws, which Bernard and others are playing a pivotal role. I want to touch on what we're about to do, and I've got 2 minutes to do it, so I'm going to show you right now. Application of social justice, which is ultimately the two doctrines of subsidiarity, that's the state serves the people, not people serve the state, and solidarity, where we act in solidarity and surrender certain rights only as far as is necessary for the making of good laws and things we can't do. Now, in 1901, if you look at that flag in the left-hand corner, that was the Federation flag. That was going to be the Australian flag. The motto of our federation is one people, one destiny, one flag. Analogous to one of my favorite leaders, Emperor Constantine at the Battle of the Milvian Bridge against Emperor Maxentius, one God, one empire, one emperor. Shortest political speech in history, most powerful political speech in history. That is a political reality, that shield you see on the left-hand side. And that is a theme that I will never forget because of its centrality and purpose. This year, this is spoiler alert, we did establish the Freedom Australia Company Proprietary Limited. Now, where's all this going? I'm going to finish on a high note here. I've incorporated this company. For those of you who know your US history, Rutherford Foundation, Beckett Funds, and other entities, I can include Knights of Columbus. The fact is there are entities out there who will kick legal butt when there's something going down, okay? They will take you to the Supreme Court circuits, they will take you on. So nothing's as easy as it is in this country, and we're gonna make things very, very hard. This touches on the sharp end of sword, using Douglas's quote of the last squadron standing. Well, we've just built a squadron. In fact, we've built several squadrons. Here they are on the right-hand side. Resurgam Proprietary Limited is a holding company, which we're going to have 5 subsidiary entities: Resurgam Education, Resurgam Finance, Advocacy, Law and Media. Its purposes are to be an integrated fighting force. It's already working on an experimental scale. In the last 7 to 10 years that A-Law, I know Oliver Hayden's paying attention at this moment to this bit. We've been having discussions about the superstructure. We'll be one integrated fighting force, which is all arms tactics within a military analogy. But we certainly are a new squadron, and we've enjoyed a very strong success at what I call an experimental stage. We're not fully operational yet, but I wanted to show you what happens next. And so I think that is the end of the presentation, and I'm on time, and thank you for listening, everyone.
Thank you, Robert, very much. You've certainly given us a historical background to set the theme for what we're discussing today. So now, Robert, you are interested in constitutionalism. The current debacle in Victoria, there are some legal people, one QC in particular, who has come out and said that the actions and rulings of Premier Daniel Andrews are not constitutional. Would you have a comment on that, please?
I have only yesterday been reading through the Victorian COVID-19 codes. There is a lot of them. I acted in the Victorian Court of Appeal, both at its state law. What alarms me the most is the physical presence of Australian military, side by side, shoulder to shoulder with police. I cannot find where, I've been looking for it, deployment of military forces is one main, because main point of contention. One, and Bernard, I'm certain I would like to welcome his comment on that, because Bernard's put a lot of effort, for example, in corollary. You've got to understand, law is not about isolated incidents. Once you set a precedent, it applies everywhere. Are we going to have military forces rolled out if you breach an exclusion zone to an abortion clinic? Are we going to have military forces rolled out if you don't pay a tax? You see what it sounds absurd to talk like that, but where did we get, I understand that there is a state of emergency law in force at the moment in Victoria, but does that translate into deployment under defence law? Bernard, who's done a lot of work on the gay and lesbian Mardi Gras and the marching under flag, in formation, under command of Army, Navy and Air Force units at that designated political rally, and Bernard will have a lot to say, has had a lot to say about that, and will continue to have a lot to say. These are the precedents, equally by extension, the Marriage Definition and Religious Freedom Act, and the use of the Commonwealth to make, and this I advocate against my own cause, of the fact that religious freedom powers are state laws, not Commonwealth. But what I'm trying to get across to you is this main theme, and that is we are seeing a capriciousness. I am not convinced that military units may be deployed at this moment. I have to find where the Governor-General by proclamation, or the Department of Defence Secretary, or some learned authority that has the power to deploy under the command power, which is a prerogative power, has the power to deploy troops, for example. I know you want to talk about the medical issues. Yes, under Victorian health law, restrictions and quarantines can be applied. However, how far can they go? That is another state law question of Victorian health law. I have read the instruments of all, there's a lot of them, by the way. I got up to 19 different instruments, but I ran out of time just reading them by coincidence yesterday. And if you asked me, what I couldn't find were things of border protections and restrictions. That's what I was practically looking for. But I read all these tomes and tomes of law on everything from assembly to religion, places of religion. The fact is, these, when the speaker said plandemic with an L, what's really going on? And my main bill I love to hate is the Marriage Definition and Religious Freedom Act of 2017, creates broader precedents, and this is something well known to Bernard Gaynor, that it might sound, it's the Trojan horse, it might sound right, it might sound correct, but would you be prepared to apply the same principle in another area of law, such as the word defence, or the word currency, or the word state? You see, once we start getting into one of the main themes of your membership being largely a rural agricultural industry, farmers, etc., that do constitute a good number of the membership of the public school club in Adelaide, the one big issue they've got is Section 100 of the Commonwealth Constitution with water rights in South Australia, which is a perennial big topic, serious topic. of catchment and water flows. All of that is up for grabs because of the precedents being set. You know, so, oh, Robert, what's marriage got to do with this? What's marriage got to do with COVID? What's marriage got to do with water? It's the Constitution, ladies and gentlemen, and it doesn't matter what the topic is. When you appear, as we have, in a full bench of 7 judges of the High Court of Australia, you know the main laws governing the ratio that is the backbone of Bernard's victories have to do with areas of law which none of you would think about, such as admiralty law. One of the questions asked that was answered by the Attorney General of Western Australia said, can you tell me what imperial laws continue to operate post-federation? And the Attorney General for Western Australia got up and said, oh yes, it was the Admiralty Court, still the Imperial Court still sat in Australia post-federation until the mid-30s. I mean, so you get these sorts of confusing, they met in rural New South Wales. But the point I'm making is, you say, Robert, you're getting all esoteric at this point. No, I'm not. When I see footage of army personnel standing side by side police, I'm immediately asking, because I was a legal officer in the military, I'm asking a number of questions, a lot of questions. How did we get to that state of affairs? There's a lot more in this than this pandemic than just health. There are precedents being set. I haven't mentioned security law. I haven't mentioned secrecy law. I haven't mentioned interstate laws, but that extremely disturbing to the point where, and the same with Bernard Gaynor in defence laws, termination laws, termination of service laws, and so forth. The list, you've got to get through your head. What's happening in Victoria is only weakening our current constitutional framework and the extant laws that are there, and then it ends up becoming prolix and complex arguments. If you sat through Bernard's hearings before the full bench, most of it would be very technical and esoteric. So my short answer is it is very much a scheme to weaken areas of law which people aren't even imagining. I'm focusing very heavily on the areas that are of most concern to me, which is security law, secrecy law, spy networks, ASIO, GAO, them. I'm looking at defense law. This is where the real action, that's where the sleight of hand distraction, everyone's talking about pandemics and wearing masks and injections and needles and stuff like that. I couldn't care less about that. I'm caring more about the shakeout of the law and the changes that are being made. And you're not hearing any commentary on that. You're not. I mean, just, oh look, there's an army officer with a MOG and in uniform, in formation, taking orders and working with police all over Victoria. And I'm saying, what the hell is going on? I mean, it doesn't matter whether they're passive or just standing there and having a chat with police. The fact that they are there, that's not an accident, and someone had to give a command order for that to happen. And I'm asking, quo warranto, what authority, what power is that happening? So there's my answer to your question.
Yeah. Thank you, Robert. I think it's a question of degrees, because let's imagine when the bushfires were on, the police and the CFA and all those people, they were probably utilised to the maximum. If the military came in to assist and stand alongside of those, people could accept it. But in this case, I can see where you're coming from. You wonder where will be the limit.
It is, as I said, a prerogative, and the command prerogative is not written. The command power is not found in the Defence Act. It's not found anywhere. An officer commanding a soldier is not. It's found by royal prerogative. That is it. And I'm asking, by what you see that, as I said at the very beginning of this address, it's about culture as much as it is about laws. You can produce another Defence Act, you can make amendments, but it's going to be how it is applied. And it's what we call, back to Douglas's big word, administration. Now, if defence can be rolled out for something like this so-called pandemic, what else can they be rolled out for, and when, and for what purpose? That's where it gets, very dangerous.
You put a lot of emphasis on justice in your address. Now, what about Professor Peter Ridd, who took it to the High Court? No, not the High Court yet, the Supreme Court, about him being dismissed from the James Cook University over his comments about the level of destruction in the Barrier Reef. And I think the ruling came down 3-2 against him. And they used the basis, not whether it was accurate, his claim, but rather that the offence it was that it wasn't collegiate. In other words, all the other professors at the university didn't take the same view, and he was the odd one out and messed up the nice little club that they had. Now, I think the standard of judge, you correct me here if you're wrong, you've had some victory, so you must have been very convincing, or you struck the right judges. But it appears to me that the judges are appointed by the politicians, and I don't know how you could do it any other way, but they're appointed to that position. They've already got a bias. Would you comment on that?
Well, for a start, we were unsuccessful in Bernard's case in his termination of commission on appeal. Bernard was successful against Justice Buchanan, and he was unsuccessful on appeal, which is why when Public School Club made me the Toast of Honour speaker following the speech of Professor Ridd, and a great play was made for me to meet Professor Ridd to warn him the Ides of March. He was feeling very confident on the day that he was your guest speaker at the Public School Club. And I warned and warned and warned. I said, the Court of Appeal, very much your point, let's get this very clear. There is still a predominance on the Court of Appeal bench of the Federal Court of Australia of what are Robert McClelland appointments. That is the former Labor Attorney General. Okay? Yeah. And they do occupy that bench. And there is a predominance of what you might call political appointments. The fact of the matter is, and I'm probably getting myself into a lot of trouble here, but the fact of the matter is, it did not escape my attention, to say the least, of the treatment in which Justices Nye Perham, Mortimer and Gleeson, the three judges that heard the appeal of Bernard Gaynor against Judge Buchanan's judgment, which we won on 6 counts under the Administrative Decision Judicial Review Act, as did Professor Ridd win in his court below. And as you touched upon, at the critical moment before the Court of Appeal, because I have read his Court of Appeal judgment, very much, I wouldn't call it technical arguments, but the same errors that I saw in specie. Remember what I just said 10 minutes ago about you don't just read narrow areas of law. Bernard's and Professor Ridd's cases are very closely connected legally. They are very closely connected because of the paradigm being expressed by the full bench of the Court of Appeal of the Federal Court. It's no accident. Buchanan was so distressed about it, he actually resigned as a judge afterwards. He retired shortly thereafter, and I cannot say that that was his reason for retirement, but I'm deeply suspicious. But the fact was, His Honour, in my view of Buchanan, was entirely correct, as my view of the judge below in the Ridd decision was correct as well. If you've read the Court of Appeal judgment of Ridd, you'll notice you talk about this collegiate issue, but they tried to veil the decision in terms of you're not competent. You're not a professor in aquatic studies of, I don't know what the science is that would touch in that area, but you're not one of them. Okay, you don't know it would be like me casting an opinion on reef science, whatever is the proper scientific field there, which I have no skill or expertise. So I wouldn't dare proffer an opinion, being out of my depth, literally, figuratively. So that's the sort of argument that was being run. But the short answer is yes. I'm not listened to when it, and this is a point I've made very often, so I'm making it very clear now. When you are on appeal, and this is what is so remarkable about Bernard Gaynor and Tess Corbett's wins in the High Court, to win up there, as George Pell will tell you, you have to really have your gear into order, okay? And not a small degree of luck in it as well. You've really got to find, and when I say luck, I mean the opponent's argument has to be appallingly bad as well. Thankfully, it was. The state of New South Wales was in complete disarray. But what won it for Bernard and Tess Corbett, and we'll see how the High Court treats Rid. But you've really got to have not just a sharp pencil. You've got to be really armed to the teeth. And I'm saying, with respect to Professor Red, he didn't heed my warnings. He felt very confident. He had this belief that he won below, he was going to win on appeal, and that spectacularly went the wrong way. And now he's relying on an application for special leave to appeal in the High Court. I wish him every success. But for those of you who know me, we had exactly this discussion with Cardinal George Bell. And it was, despite the final outcome, it was very touch and go, because don't anyone think, it's like saying, well, of course the Allies were going to win World War II. Really? It got right down to the wire. A matter of a couple of months in history could have changed had the rockets, German rockets come up, it could have been a different ball game. Appel could have easily lost that High Court decision, easily. And let's not be under any illusion. If it gets to that state of affairs, that's your last roll of the dice. So I say that yes, if you pay attention to Donald Trump, what was the first thing he did, or should I be more specific, what was the first job he delegated to the Vice President, Pence? The Supreme Court of the United States appointments are going to start changing, and they've been flushing out the judges for the entire term since 2016, putting in new judges, conservative judges, and getting rid of the old guard, because quite frankly, if you do not have a judicature that can be even-handed, you are doomed. And that's very much where we are at the moment, I'm afraid to say. I take nothing away from the judges. I mean, they have a difficult job to do, and they are certainly having to have regard to the law. But I'm resting firmly on my belief that the full bench decision in the appeal court against Bernard was a terrible decision, absolutely awful. I can equally say, having read the Rid appellate decision, that was an equally terrible decision in common law. By the way, it has been heavily criticised. I could also introduce a third case that probably no one even remembers now, the Hoxton Park appeal cases. I mean, that too, terrible law. And these terrible laws are being, and heavily academically criticised, okay? Dogs, Defence of Our Government School legislation, Commonwealth block grant authority grants, atrocious laws that are now costing, back to Douglas, money, lots of money being wasted. In the case of the Hoxton Park, $43 million of misappropriated Commonwealth monies. Total. Now the Commonwealth have issued orders. The state of New South Wales sued AFIC for $9.8 million in 2015. So it's not me. Again, I'm not just having a rant here. This is the economic, legal cost of bad law, and so Trump is definitely on the money, putting it bluntly, to get rid of judges. And of course, you've got that. I think it's Robinson. Oh dear, the attorney saying, "I wish to discontinue proceedings," and the judge saying, "No, you're going to continue on." What judge can force a prosecutor on? I mean, this is insane. And acting as if the judge is a party to the proceeding. I mean, this is where you start to step. Well, this isn't stepping over the line. This is just a judicial collapse going on. And we're not quite there yet, but certainly the partisanship in the nature of the judgments. I heavily criticise the full bench in the Gaynor appeal cases. I heavily criticise the full bench in the Rid appeal.